Sorry about the a minute or two delay, but we're here now. I'm looking forward to this great conversation with Hanan Isaacs.
Hello, Ken.
Hello, how are you?
I'm great.
I remember you from back when. Um,
Listen, you're the only guy I know from Fairlawn.
well, that's kind of saying a lot. I mean, it's funny because I go to Fairland every once in a while still, but it's definitely a much different town than I remember.
Yeah.
Um, I think, you would give me some insights as to things to speak about, and I think this is going to be a great conversation with all the changes going on. I know we're here in New Jersey, and I know you wanted to speak about some of the generic or the different developments in the states around, as well as federal law. So I would love to hear because I try to catch up on as much as I can, but I'd love to know what your take is on things.
So I want to start by saying it's not uniform and it doesn't only move in one direction. The New Jersey legislature, I think, prides itself in the past 50, 60 years on being ahead of the curve in protecting workers' rights.
Hmm.
And we're talking here in the non-union setting, although New Jersey also protects union workers' rights, but federal law really steps in mostly for that. But these are negotiations that happen between you and the company. The company could be two people, 100 people, 10,000 people, and the bigger it gets, the more difficult it is to negotiate with them. So New York, New Jersey, and many other states have been moving in the direction of what I have called, others have called pay equity, things that remove barriers to people not getting similar treatment based on race or age or gender or uh, sexual identity or those types of things. Now, at the same time that I'm saying that, we have other jurisdictions that are moving exactly the other way, who say things like we shouldn't be having certain conversations or we shouldn't be protecting the rights of people who are different from us. So I'm really talking about what I would call more progressive oriented jurisdictions. So New Jersey has done a lot to um, produce better results for workers, even who are not affiliated with a union, as
Hmm.
far as being able to talk about how much do you make, Ken, as contrasted with me? Are we doing the same job? Is there a reason why two people coming in at the same time, one is making much more money than the other? Some companies, many companies, used to say to people, that's improper. Don't talk about that. If you talk about salary, income, it's a firing offense. New Jersey a few years ago said, no, it's not. How about saying things that are critical of the boss or the manager? Um, Used to be that was a firing offense. You wouldn't believe the things that the National Labor Relations Board has said in the past few years are actually okay to say about the boss, as long as it can be construed that it's in the nature of talking about conditions of work and the pay that people are getting. And if people express themselves even in very floral ways about the management, it's construed as free expression, basically.
So from a federal standpoint, um, are there some? I mean, there are some things that are supposed to be in place, but is there, for example, when I was hired at will, and that basically means that I'm there at the as much as the company wants me to be there, but I don't necessarily have recourse per se if they decide to terminate me. And I don't know if that's something that goes across all different states or how that works.
So I'm going to say the floor in that analysis is what does Title VII to the United States Code say about that thing?
Hmm.
Because states can increase rights, but they can't go below the floor of the federal offer. And so that would be things like, um, you have the right to be free of discrimination and retaliation. Most jurisdictions, I'll say all, will have an at will type of approach. And the thing is, I say to people, they don't sort of get it necessarily philosophically because they're having a very specific problem. But what I say is, at will protects the worker also. Because can you imagine if you decided you wanted to leave because you didn't like the conditions at the place and you found someplace else, having the boss turn around and say, wait a minute, you can't leave because this jurisdiction says you're indentured or something like that. That would not work well. So the at will is really when you decide you want to leave, they can't stop you. If they decide they want you to leave, you can't stop them except if their reason is unlawful. When I say unlawful, I don't mean criminal. I mean there's a civil, uh, a public policy that says don't discriminate against people based on race, national origin, religion, etc. And if they raise the issue to you, don't retaliate against them either. So if you come forward and say, I think there's racial disparity going on here or gender, and the boss says, oh, don't worry, we will investigate that completely. Mm-hmm. And they go, oh, and by the way, gather your things, we're escorting you out. That's retaliation. So that's also federally protected as well as in New Jersey. New Jersey has a statute, we call it the LAD, the Law Against Discrimination. It does a lot of what the federal law does. It actually goes further in terms of certain protections.
So I'd love to open this up. I see a couple of questions in the chat. I mean, if you have specific questions, especially as people are now being laid off and in terms of notice or in terms of what the next steps are. So this is a question which came from Sam Anson. Does a non-compete agreement expire if you are fired or laid off? Or same for like a material change or a merger?
This is a wonderful question. The answer is at the root of it, no. It doesn't expire just because you're fired. It actually will, if you have one, it will tell you that this will continue regardless of how you separate from this company. Whether we ask you or you tell us, either way, this non-compete continues. Now, the area of non-competes is exploding. There are companies, I dealt with one of them because my client was being laid off, where they were very enlightened. And they said, their agreement said, we have a non-compete. It goes for 2 years. It covers the United States. And we might not care. But if we do, we're going to pay you as if you were working here to sit on the sidelines for 2 years. That's really a good idea, I think. Because A, how many employers really care about the competition? Well, if a contract provision like that's in place, we're going to find out. That's expensive. But B, the state of New Jersey has a bill pending, which I'm not saying it's going to pass so quickly, but it's posted as a potential law that does exactly the same thing. And it really cuts the guts out of non-competes. It says it only applies to certain layers of workers. Can you imagine this, Ken? A few years ago, New York City told the people who were frying French fries in McDonald's franchises, if you go across to a different employer, you're not allowed to fry their French fries. Because why? We have a proprietary way of doing that, and we don't want you giving them our work product. That's ridiculous. I don't think a judge in the universe would ever uphold that. But the mere fact that companies are thinking of these things, it got the New Jersey, whoever sponsored the bill, thinking, what level are we really trying to protect? Is it intellectual property, trade secrets, kind of high level stuff that's really dangerous? Or are we going to allow judges to enforce them just because they say you have to sit out? It's a vicious area to uphold, because it basically means in the most important area of your career practice, you're out of work. You can't do it. Now, if they say 10 years, the whole world, and you've been working for a mom and pop store, that's not going to be enforced. I don't care what it says. That's non-enforceable. But there are some that will bite you.
So what I wonder about, along those lines, since we last chatted, there have been some changes. Like one of the changes is salary requirements being listed in job specs. That's a very big thing. What I find, and a lot of people in my space talk about, is that the ranges are so so big. You know, you can have a range from like 10,000 to 100,000. What good is it? So, is there some way to have some range, like a 5% above or below, or is this just going to be playing whack-a-mole? Here's a new requirement, but here's a way to work around it.
Right. Excellent point. I would say we have to look at what's public policy telling us, people who are in leadership roles in, say, the New York City um, council, which is what created that law. And I believe there could be something in another state, maybe California, that's doing the same thing. I don't know if that's been proposed in New Jersey, but that complaint is valid. One of them that we were sending around a month ago said the range is $60,000 to $600,000. That's not disclosure. That's obfuscation. Now, in New York, they have a commission that's supposed to look at those types of things. And it's going to take time to work out if somebody is held to be in bad faith for doing that, because they can be fined for that. And it's the carrot and the stick. If you obey it and you're reasonable, good things will happen. If you transgress it, we're going to bring down the weight of, the gods upon you. So that's to be determined. But it's an important point. You create something that says, make this a meaningful thing for workers to look at, so that A, know whether they're pitching in the right ballpark, and B, that essentially you're not going to dumb down that job. Because if they said it's worth about 100,000, and you come in and they say, by the way, how much do you make now? Oh, I'm qualified, but I've been underpaid, so I'm making 60. Congratulations, we're offering you the job. That's what this range is supposed to be for, is to say, we're not going to dumb it down to 20, 30, 40,000. And not only that, New Jersey, for example, says, don't ask the person's last salary. The only time the employer in New Jersey can do that is after they've offered you the job. And why is that? So they can confirm it. Because if you said, I've been making 80,000 and you're making 25, maybe that's a problem from their point of view as far as what your experience truly is.
So a few questions have come up. Alex and we were all joking earlier today about today being Purim and all that. I want to observe a Jewish holiday. Can my boss object to it? And I would even talk about Jewish holidays, Good Friday, anything like that. The way that the workaround has always been for me is they have told me when I've been working, I can take them as vacation days or personal days. But legally, is there anything that a boss can basically do to object to it?
So the first point to be made is religion is the favored child in terms of people's rights today, at least from the point of view of the U.S. Supreme Court. So anything that I say could be different 2 months from now, but they are really, really pushing that people have the right to expression and these sorts of things. But I'm going to say, in terms of the state of the law, the best I could say, companies should grant what are called reasonable accommodations. Now, you may remember that in the area of disability law and the Americans with Disabilities Act, that's exactly the same phrase that's used. Mm-hmm. And it has the same meaning. Is there a burden on management that's so high that to grant this particular request, because it's not going to be just to Ken and Alex, it's also going to be to somebody who's Muslim, somebody who's Christian, somebody who's Greek Orthodox. My own thought would be, from the point of view of an enlightened employer, give people as much as they need. Say yes as much as you can. You could say that's not an official holiday for our company, but you can take it as paid time off, right? So again, there's a give and a take. Mm-hmm. I don't think most employers are going to say, Shmini Atzeret, sure, unless they're observing it also.
Sure.
Or St. Smithon's Day, unless they're observing it, or they tell the whole company we're off. Chances are pretty good the reasonable accommodation is going to be take that day off and work the rest of your time. However, what if it's crunch time? You're in an accounting company and it's April 14th and the returns are due on the 16th. And this person says, I'm taking off whatever, there could be some pressure there. And I'm going to say, if I were representing an employer on something like that, I would do everything I could. I'd bend over backwards for religious exceptions. But I'm saying now, some of them will say that's a burden. It's unfair to us. We need to get this out the door. If we let you do it, a lot of people are going to do it, and there's where the fight comes up. Or you don't show up and they fire you because you were absent without leave.
I know one thing that's happened a lot since we last spoke are all these conversations about people. They go into work and all of a sudden they've lost access. They've lost computer access. They're kind of shown the door that day. And again, I don't know specifically if there was any communication before. I'm not at the companies. I know it's posted, but it just seems to me that that seems to be taking things to a major extreme. And I know a company may be concerned about, if we give you notice, you're going to take their information, you're going to do bad stuff and all that. But it just seems to me to be almost draconian with what that is.
Yeah, I've had plenty of clients where that was the work policy and that did happen to them. They felt shamed about it. It was almost like they were being, frog marched out the door in shackles. Management can do it. They can cite a security concern about what happens if and what will you do to your computer? Will you mess it up? Will you take something? I can't really get into that mindset. I've always used the idea that I want to be good to people, even in an exit interview, and say, here's what happened. We tried this. It seemed to work, but then it didn't work. I'll give you a reference.
Mm-hmm.
Here's your unused sick time or PTO, but unfortunately, some employers, it's more like a pitched battle, and they know where the enemy lines are. I mean, you can imagine, working for Tesla, what their policy is about when they walk you to the door. I think it's gonna be tough.
Right.
I also want to say to people, watch out what you take, because let's say your computer's down, things aren't working exactly well, but you have a desk filled with documents. You can take anything that involves you individually, emails, memos, things that you worked on that are not proprietary. But you really got to be careful about taking stuff that doesn't belong to you, especially if it's like private information. There's a case in New Jersey, very nasty situation, where an employee was working at a school and she had access to student records. And she was upset about something that they were doing with the kids. She took stuff that was HIPAA protected and ended up being charged with a crime. And a lawyer was threatened who got those materials and started using them in the case with being an accessory. So these days in the employment law world that I'm in, the lawyers say to each other, you can ask generally what those people have in their possession. Tell them don't bring it to the meeting, and tell them I don't want to look at it, because you can't unsee it. I know, and this sounds a little bit like walking people out. It's like there's a concern about what could happen. So you start changing the practice that you've used for 50 years because something bad could happen.
What about your reviews? Like can you take along your reviews? Is that considered documentation?
But here's an interesting thing. You'd be shocked how many times I say to people, were you getting performance reviews? Absolutely, every year. And how many years did you work there? 20. Do you have your reviews? No. Because maybe management never gave them a copy. And they had it and they got rid of it. But I think that's extremely valuable. That's one of the key things that lets a judge, a jury, your lawyer know whether what's happened to you is what's called, in fancy word, pretextual. Another word for that is a lie. They said it was for this reason, but it turned out to be that reason. We had a guy who was transporting NASA rockets on the ground because they got to get from place A to place B without flying. And they had to take down phone poles and wires. And he did this. He started out as a truck driver, but by the time he was in his early 60s, this guy, he had books that people put together showing photos of all this stuff. That guy was, and he had a letter of commendation for 10 years from the owner of the company. They fired him and said it was performance based. And all we had to do was pull together all the stuff that he had and said, are we talking about the same guy? And we settled his case. So those pieces of evidence are very important.
So a question from before is the salary disclosure, is that a law or a recommendation?
Salary disclosure, meaning I'm going to guess one of two things. One, Christine is talking about
job specs, let's say.
I'm sorry?
In job specs, like listing what the salaries are. Perhaps.
That is, I don't believe that is a New Jersey law at all. That's a New York City law, and it may be California or someplace out west. They've got to disclose the salary, right? The other thing she could mean is, are you allowed to talk with people about your income, which I already said that you are. But New Jersey, I don't believe New Jersey so far, what it did was say, you're not allowed to ask, what do you make today, Ken or Christine or Alex? Tell me your salary history for the last 15 years. And the reason for that is the same thing as the salary range, because they're going to dumb down the position. If they can get a Ken for 50% of what they could get some other employee, why wouldn't they do it? So essentially what the legislatures are saying and the city council, as a matter of public policy, we don't want people getting tricked. We don't want them being trapped. And one of the ways to do that is through not the employee's disclosure, but the employer's disclosure. There's another point I want to make about disclosure, which is really two. There's sort of two sides of a coin. New Jersey is interesting this way. It's an indirect way of getting at the problem. There's a lot of people who are getting welfare benefits. They can't get a job, some of them because they have a criminal record. So New Jersey, some years ago, Philadelphia, in its city council, passed laws that say you're not allowed to find out whether somebody has served time, except in cases of, let's say, unemployment for the Bureau of Investigation, the city bureau, the police. Maybe there it does matter. But in most other instances, the thought is, as soon as you tell me that you've done time, I'm not going to even think about your application.
So this is another thing.
Does something that says, don't ask it.
So here's the thing. It's illegal for a company to terminate someone who found out negative things about a company via a former employee.
It's a little hard to interpret this.
Cindy, if you want to clarify that, that might be better.
So in other words, the company hired somebody who found something out, who was a current employee.
Right.
But a former employee said something that was negative.
I guess.
And just for that, can they turn around and terminate? This is in the category of there's no law against stupid. There's not. I wish there were. But this is the type of thing. When we talk about discrimination or retaliation, those are really specific things. But if you don't have one of those and all you have is employer dumb, that's not actionable. It's not actionable. We don't have jobs for life. We don't have multi-year contracts, most of us, that say you can only be terminated for extraordinary, bad faith or moral turpitude or something like that. At will is low. You don't even have to say there's cause. It can be without cause. It turns out I don't like you. It's not because of race, creed, color, national origin, or 14 other things under the LAD. It's just I don't think you fit here. I don't like your personality. I think your sense of humor is terrible. You know, it sounds stupid, but people make decisions, and as long as it's not illegal, they can do that. So here's an example of employee A leaves, tells employee B on the way out the door, do you know what those people did? And the company finds out and says, employee B, you're out. Dumb, but I guess maybe they didn't want to tell employee C. I don't know, but it's not unlawful. That's the best I could say.
For me, and this happened, this is a true story. In 2008, when I was terminated, I was not, I had trouble getting unemployment because the company said I resigned when I didn't resign. Right. And I had a severance agreement and everything like that. And I think a lot of companies, I don't know if they still do that or not, but unless you're really careful and you read stuff, you know, you have to be very careful how they portray things.
Right. Well, this is an interesting thing. First of all, severance agreements, they're not mandatory. It's optional. Many companies have them, especially at the upper levels. Sometimes they have a policy how much you're entitled to because they don't want to fight about it, or have employee A tell employee B out the door, here's what I got, you know, and then employee B says, I happen to know what you gave A. So some of them publish things like that within the company, others don't. New Jersey allows you to collect your unemployment even with a severance agreement. That's unique. So you're getting money for not going to work for, 3 months, 6 months, a year, whatever it may be, 2 weeks. There's no law of severance. It's whatever they want to give. And at the same time, you can collect your unemployment. New York does not allow that. New York state law says, come to us for your unemployment benefits when your severance runs out. So you have to be aware of that in your particular jurisdiction.
So you also you wanted me to talk about job negotiation skills,
yes,
influenced by law, although, and so what did that actually mean when you talk about negotiation?
Well, what I wanted to bring up is something that I have not spoken about in the 5 or so years that I've been doing work with the job seeking community, is really sort of how I got into the world of negotiations, because most of what we do has to do with, I want something, I need something, I contact you, you're in a position where you're selling it, or you know somebody who is, you're brokering it, and we need to learn how to be better negotiators. And that's a ton of what I do in what I call legal consultation, right? We do litigation, but most of the time it's people coming in saying, I'm about to get fired. I went on a PIP. I have been fired and I have to deal with this crazy non-compete. I'm going to the next job. How do I deal with this, that? So in the middle of my legal career, I had the fortune of working with a professor from Harvard named Roger Fisher. And many of you on the call may remember him from his books. Getting to Yes is probably the best known. He co-published it with a much younger teacher at Harvard named Bill Urey. And I was able to actually study with both of them. This is interest-based bargaining that's based on game theory. And what it basically says is 95% of the work that you're doing in the negotiation happens away from the table. Don't even sit down with the person on the other side or the other team until you figure out for yourself, what do I want? And most importantly, why do I want it? If you ask people, why did you get that car? Why did you quit that job? Why this, why that? They're like, I haven't really thought about it. It was just time, and I liked the color, and I needed more time off. But if you're in a major negotiation, you're going to want to be able to answer the why. And so you figure out your own interests, and they're going to be multiple. It could be money. It could be culture. It could be respect. It could be growth. It could be many things. You also want to sit down for yourself and figure out what's their interest in this negotiation. What do they want out of this in the same way? And then you have to develop your options. I could do this with them. I could do that. Just list them all, brainstorm. My wife, who I love dearly, is a terrible brainstormer. As soon as she says, let's figure out we want to go on vacation, and I say, what about the mountain? She's like, that's a terrible idea. Okay, that's not good brainstorming. Brainstorming is Anything you think of, you write it down and you go, maybe that's it, or maybe that's it. And you can sit down with somebody else and actually work through what could be a great way to deal with that. And you also brainstorm for the other team, even though they're not there. And what you're doing is you're trying to develop a mindset of what are the triggers? What are the things that are going to move the negotiation more positively or negatively? A very important thing, especially in the job negotiation world. And we're always negotiating about everything, right? Look elsewhere for what you're asking. Why? Because if you can get the same or a better deal elsewhere, your power in this negotiation, my friends, has just gone stratospheric. If you find out you can't, because this is the best you can do, you better know that, right? We don't do this based on personalities. We don't say, I'm going to that doctor whose resume is very unimpressive because I like her. You're going to say, I want the person who could do the best job, which means you might actually need to work for somebody you're not totally thrilled with if it otherwise meets the things that you need. If that's the top thing you need, then you're not going there. But this is what allows you to do that. So Fisher and Ury taught that you make your choices on the merits, right? It's not personal. You want to be soft when you negotiate with people, not yell, scream, carry on, bang your shoe on the table, but you want to be rock hard on the merits. So here's a good example. Fisher used to say, one of his students wanted to buy a house in Cambridge, and the student did everything I just said, everything. And he goes to the seller, or one of the seller, knocks on the door, says, I'd like to buy your house. The guy says, it's not for sale. Well, I've done the market research and here's what it's worth. And the guy's like, that's what it's worth. I want twice that. And the guy says, well, why? The kid says, why do you want that? He goes, because I want it. So he leaves. He goes to Fisher. He says, Fisher, help me out. They go knock on the guy's door, and the guy says, I will not take a penny under $1 million. Fisher says, but my student here proved that it's only worth $750. Guy says, all right, $999, $999. Fisher goes, I now understand the bargain. We offer $1. Because if that's the game we're playing, if it's unmoored to the marketplace, my dumb idea is no worse than your dumb idea. But this is the kind of thing that you need to think through and really develop that strong sense. And the strongest negotiator, I wrote a note to you about that, Ken, but I didn't tell you who it was.
Okay.
The strongest negotiator in any negotiation is the one who doesn't really need the thing being negotiated. They're in absolutely the best position. Banks are throwing money at rich people. But if you're a bag man or a bag lady going into the bank, they will escort you out. You're not, even though you need it more, because you're a bigger risk. It's the one who poses no risk. And so I say to people in the job search, look at all those pieces. Don't be afraid to try it. Go out, ask, test it. Go on these like opportunity interviews. Get your entire world view mapped out, and then you're ready to actually do the negotiation. Now, there's another side to it. Not everything is negotiable, right? Fisher used to say, don't go up to a Coke machine and say, I only want to pay $1. You're not getting the soda. You have to put in the full amount. That's not negotiable. So you have to know that too. I'm not offering pie in the sky. I'm saying open your mind and realize there's more to it than you might have thought. And it's only in the thinking process that you will actually be able to access that.
The other question I get a lot of, by the way, that was a great answer. The question I get a lot, people they pretty much know some of the off-base job interview questions now, but they still may get them. So what's the best way to turn that around to the employer in a way to say, I really can't answer that, it's legal, or is there no way around that?
You know, in 5 years of working with this community, this is the only question I have not the best answer for. It would take Harry Houdini to get out of that trap. And one of them he didn't get out of, by the way. That's the one that killed him. So what I'm saying to you is I know what I would do, but given what I've just laid out, if your highest interest is you have to get an income because you have to pay for your family and yourself, unlawful questions might not be a deal killer for you. They would be for me, right? Because I would say, and I got this really from my father and he from earlier people in his family. I have to believe if they're asking me illegal questions in the interview process, how's it going to be when I start working there? In my view, it probably is only going to get worse. Maybe I'm wrong. Maybe things work out. But I kind of look at that as part of the negotiations. I look at the interview process as part of the negotiations. And if people are, lining me up with a robot to ask me questions, lining me up with a video that gives me one chance out of how many questions to retape it, and then I get this and then I get that. At the end of the day, I'm going to be uncomfortable. That's just my supposition. So the thing that I would say is I cannot answer that question, or I've been advised that that's a question I'm not supposed to answer. And you're being brave. One of a few things will happen. One, they'll respect the heck out of you and go, wow, we weren't thinking about that. Two, they're going to go, this one's trouble. Don't even, respond. And then three, I don't know, fill in the blank. You take the job, you take your chances.
It's like the other thing we talk about a lot with the age discrimination, and people, again, it exists. We know it exists. It exists. It's young, it's old, but proving it is one thing, and you have to deal with it. You can't make that up.
That's a very important point, and I wanted to make this point. I'm glad you brought this up.
Sure.
In my office, we don't file lawsuits all the time, right? We're very careful. First of all, we don't want to stress the person. It is very stressful to go through a lawsuit. I have a friend who was telling me about her suit against her company, which is a big company, 7 years. Can you imagine? And then how are you supposed to go forward? And while you're going forward, you're still looking back, and they've got hooks in you. And now she stuck it out, and she ended up getting a good settlement, and I'm very proud of her for doing that. But most of the people I deal with, they're just not in that place. So what I try to do is say, let's fix this the best that we can. Let's see what we can get. And I always say, get the best offer without having to sue. And when I'm convinced that that's where they are, I'll tell them, we've done the best that we can here. Now, having said that, I have a really good whistleblower case that we're going to be filing this week. It's the best case of its type that I've ever done. Mm-hmm. New Jersey's version of that is you were in a company, you saw something, you told it to someone, usually a manager, the board, the boss, the whoever, and they may investigate, may not investigate, but either way, they fire you. They're like, we don't like that you said that because that makes us look bad, or it might make us look bad. It's unlawful. It's as bad as discrimination. It's just a different kind. It's discriminating. New Jersey protects whistleblowers because they do it on behalf of society. If Ken Lang points out poison coming out of the wastewater treatment in Fairlawn to the wastewater treatment in Fairlawn, where he's a worker, and they fire him and continue to do what they were doing, all of us are worse off for it. So this woman was a high-level financial person in a company, found fraud, reported the fraud. The fraud was investigated. It was whitewashed, and she was walked out the door. That's a good case, right? But a lot of these cases, they can't afford it. The people, they can't afford the time, the stress. And I say to them, then don't do it. You don't owe it to yourself to embroil yourself in a lawsuit. And by the way, at the end of the day, you could lose. Can you imagine? And then on top of all of that, almost everything that happens in the court system today is public knowledge. So the press finds out about it. The next employer finds out about it. Right? We had a kid from Princeton we represented some years ago who was involved in some very nefarious behavior, ended up moving to a totally different part of the country, And he says to me, my life is ruined. If you type my name in, you're going to find what happened. Right. So that's a very strong follow on. So you have, frankly, the only people who it's worth suing with as a client, they have to be built like a battle tank. They have to love to fight. Bring it on. The more you do it, the better I like it. Not everybody is like that. So it's perfectly okay to make your best deal and walk.
I think also the last couple of years with remote work and more people at home, the policies have definitely changed. I've heard so many stories about people who have their keystrokes being monitored and their website stuff being monitored. And I guess it's all legal, but it brings up a whole different layer as to the whole process.
Yeah, I really don't like that personally. I reject that. I think that some jurisdiction is going to say no, maybe New Jersey, maybe elsewhere, that there's a privacy issue. So I'm not going to say whether that would hold up, but we know it's out there. It's nefarious. It gets into the bones for people about that sort of thing. I mean, I have people who work from home, and you know what, Ken? I trust them. And if it turned out for some reason that I learned, not through spying, but through some means other than that, that there was, that somebody was being in bad faith like that, I would deal with it in a disciplinary fashion. If it was, I mean, I had somebody years ago actually who worked for me, and I happened to be using her computer one day. Nobody was around. It was like night and evening, and I'm looking and I see some stuff like right there, some email, and I opened it, and her friend was yucking with her that this young woman was calling me stupid and strange and weird, and so I wrote a very nice note and said, you shouldn't have left that where you did. I did see it. I don't appreciate it. You shouldn't be saying that to people about me, and it has to stop. Well, wouldn't you know, a month later she did it again. I'm like, okay, we're done. This is like what you do. But I didn't do it with malware or keystrokes or whatever. It's just you happen to find it, you know.
I think also nowadays with social media and LinkedIn and Facebook, all these stories get out about the best, the bad behavior of companies and what employees are doing to push back. And I think there's a lesson there. Like if you've been canned, you really don't want to start putting out your dirty laundry there, whether it's fair or not, because you're going to need another job. And companies should be very careful about how they portray themselves too.
So why didn't anybody tell that to Prince Harry? A couple of points come out of that. It's an excellent comment. Companies are firing people online, right? So tune in at so and so o'clock, and we're going to have a group meeting where we're going to tell you something very important. That is just beastly. We are so far from humanity there. How much did that save them? The other one is, I say, the worse it gets from the point of view of the worker, the more unions will make a dent. That's where you can match power for power. Now, you can tell me all you want about Jimmy Hoffa and bad things that unions do and the slush funds and all that. What I'm saying is that's a counterweight that we should not ignore. It's still legal. Since 1935, we've had 90 years or so of unionism. That's where people make up their power. And I said before about negotiating and who's got the strength and who has the need or not the need. When you're talking negotiations, if it's Ken Lang versus Microsoft, and I'm his fearless lawyer, I'd sure as hell rather have union local number 2510 of the electrical workers versus Microsoft, because they're going to pay attention, because at the end of the day, if they screw up that negotiation, there could be a strike. I mean, so that's where, by the way, that is why unions were outlawed in the 1800s until 1935. And that is where the Pinkertons came in to break unions and bust heads because the owners knew we don't want our power messed with. We want to be the only one in town to be making those rules. So the more the behavior gets worse on the side of management, the more you're going to see unionism raise its head.
I think I think a lot of places have been very complacent using the technology, and they just don't realize that there are people on the other end. Um, Easier said than done, I guess, but it's just amazing to me um, how there's such a lack of humanity in all different ways. Yep.
Well, it's sort of what the traffic will bear, you know? And also think of it this way: if you have somebody, some group that's doing something that you would not have done, but they're getting away with it, and it ends up costing you more because you're doing it, quote unquote, the benevolent way, there's got to be a temptation there to say, well, if that passes, then why can't I be doing that? You know, I don't recommend that,
Right.
but I think that's where the pull comes from.
I think if there's one other takeaway, it's that not everything is actionable. Not everything is you can sue for. And I think I don't know that that's still the case, but you have to look out for yourself. You know, whether you're job search, and just know what your rights are.
Yeah. You know, that's a great point, Ken. I say that to people 10 times a week. And I'll say even beyond, even if it is actionable, the question is it right for you? So there's a difference. You said before somebody kind of fallen down and they can stand back up. Yeah, if you're in your 20s through your 40s, I'm going to be saying, are you sure you really want to take the time and trouble? Because it's going to take you time, right? You're going to be answering discovery for the next 2 years and depositions and whatnot. Or can you go elsewhere and do well? You know, I say to people, you know, the best revenge is a well-lived life. You get to drop it, walk that way. I've had
Mhm.
people call me years later and say, I was pissed at you at the time that you said that, but it turned out to be exactly the right thing to do. But sometimes things are even actionable and they're ultimately maybe not worth doing. Where it becomes much closer as a question is when you're 60 and this was probably your last job, or you thought it was your last job, and you put in 35 years, like my rocket guy, right? I would have been upset with him for not filing that lawsuit.
Mhm.
I mean, where's he going? Right? There's already, you're walking into age discrimination. You know, the fact that he has a lawsuit pending and the new prospective employer found that out. There's he's almost got to do it at that point. But again, it's up to them. But I do look at age as a very important factor. I'm not saying that a 25-year-old or a 35-year-old can't have a case for some type of discrimination. Of course they can. But I look at it more like, what's the survival rate? Right? If you got a problem at 35 and the same problem is affecting a 65-year-old, it's not even a close question. I mean, not all lawyers probably raise that issue. I do. I want to know, how's this going to fit for you, for your family, your loved ones? You know, all of it. How are you going to feel? Are you psychologically geared for this? Do you suffer from depression? If I have somebody who's already on a disability reasonable accommodation for emotional problems, I'm going to strongly advocate that they not file a case against the former employer. That's going to be hell for them. The terrible things that they were feeling on the job are going to multiply when they get into depositions. So we have to think of these things. We got to look at the person, not, like when I was a young lawyer, it was like, it's about the fight. Let's get in there. I'm going to knock that other lawyer off their horse. And my poor client is getting dragged through, kind of hooked to my horse with a rope and just getting pulled. Do you like it? Is it good for you? You got to think about these things.
So I want to thank you very much for the conversation, the chat today, Hanan. It's been great seeing how you've developed on the platform and everyone else, and you're always available to have these conversations. It is so great.
Thank you, Ken. I also want to do a shout out to Shelby Buck, who's my
Sure.
legal assistant and has done such a great job helping me get ready for your show and
Sure.
PSP and the Breakfast Club and some other
Yep.
things. Yeah.
All right. So I want to thank everyone for attending. Have a great day. And we'll talk soon. Bye.
Take care.